The next matter to come before us this morning is Jerry Smith versus Heslop, Inc. Both sides have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. Let's see if you'd like to reserve any time for rebuttal, let me know. I'm keeping the clock, and I'll keep you aware of the passage of time. We've read the briefs and are ready to proceed when you are. Thank you.
Your Honor, I'd like to reserve 3 minutes for rebuttal. May it please the court, counsel, my name is Jim Gutbrode. I represent the appellants Jerry Smith and his son Jeremy Smith. This court decided a case about a month ago, a little less than a month ago, by the name of McHugh versus Zatar. The citation is 2015 Ohio 143. It is similar in many respects to this case. In that case, Judge Moore wrote the opinion, Judges Carr and Belfance concurred. It was similar to this case insofar as the case involved a landlord-tenant dispute. The landlord failed to install handrails on basement steps. The plaintiff claimed that it was a violation of the Elyria Building Code and 5321.04a. Tenant filed a motion for summary judgment as to negligence, as I did here, and made the argument of negligence per se, as we did here. The landlord filed a summary judgment motion based on an open and obvious doctrine.
I'm sorry, counsel. I'm having trouble. I'm having trouble with my iPad, so
Sure.
I'm trying to find this. Did you file a notice of supplemental authority on that case?
I did not. No, I just wanted
You
to
realize our local rules require you to do that? So.
I don't know that, Judge. I just wanted to...
Because we try not to do, they call that argument by ambush, so the other side gets
Okay.
an opportunity to respond.
I can pass it on, Judge. It was just decided less than a month ago.
Well, I'm not saying that we won't consider it. I'm just saying, that, technically you're supposed to file a motion to supplement, and that way your opposing counsel will have an opportunity to respond to it as well.
Do you want me to skip my argument on this, Judge?
Well, it's up to, I'm just throwing it out there.
Simply the point that I want to make is that the trial court in that case reversed. After the trial court, the trial court in that case ruled in the landlord's favor on the premise that lack of a handrail was an open and obvious danger. Did not address the negligence per se issue. This court overruled that and reversed that decision. The landlord's violation of 5321.04a 1 or 2 would constitute negligence per se. Negligence per se bars the open and obvious defense, and this court remanded because the trial court failed to analyze the negligence per se claim. The court in that case referenced the Harris-Coker versus Abraham case, a case that was an opinion that was written by Judge Carr, and in that case the court said, while allowing that the court applied the same standard as the trial court in a summary judgment situation, the court stated, however, this court remains a reviewing court. As such, this court will not consider the issues relevant to a motion for summary judgment in the first instance. And cited several cases. The court then went on to say, the trial court, however, failed to analyze the issue of negligence per se in its judgment entry. Accordingly, we are compelled to reverse and remand the matter to the trial court to consider the claim of negligence per se in the first instance. This court, at least on these 2 occasions, has declined to address a case like this, a landlord-tenant case, where the negligence per se claim was made when the trial court did not address that issue. And the trial court in this case did not address any issue, simply said that the Heslop, the defendant landlord, wins, and the landlord, or the tenant, Jeremy Smith, loses. I'm not aware of any material dispute of fact in the case. I think Heslop wants to argue about causation, and saying that there's a superseding, intervening cause, but I don't think we're there yet. The issue is what law applies to these facts. We even agree that Heslop had a duty to abide by the Ohio Building Code in the construction and maintenance of the subject apartment complex. So the only issue really that this court is being asked to address is which law applies to these facts. Which part of the Ohio Building Code applies to these facts? A window in building architectural language is called an opening or an opening protective. It's defined in the Ohio Building Code as a door, window, shutter, or other similar device, and its frame, hardware, and other accessories. The next question is, what is required in the building code of an opening protective or a window? And the Ohio Building Code says it depends on where it is, depends on where the window is. And it says that Class B openings are in enclosures for vertical communication through buildings, such as stairway, elevator, and hatchway enclosures. Very clear. It talks about the window, and if a window is in a stairway, then that window is a Class B opening. And it says that Class B openings may not have more than one wired glass panel, which shall not be more than 12 inches in width or height, and not more than 100 square inches in area. Nobody disputes that this window did not meet, by any stretch of the imagination, that requirement. There's no defense objection to that. We agree on that point. The defense in response says that particular provision doesn't apply, but they don't give any reason as to why it doesn't apply. The Heslop's expert says that it was taken out of context and that therefore it doesn't apply, but he doesn't elaborate on how it was taken out of context and why it doesn't apply. The defense instead refers us to a section on structural elements of buildings, and basically talking about the walls and the roof and so on. In the section that the defense or the appellees rely on, there's no mention at all of windows. No mention at all of opening protectives. It simply deals with structural elements of buildings. And the expert for Heslop had ample opportunity to tell us why that section applies as opposed to the one that deals specifically and directly with windows, and failed to do so. He simply said that if a window is in a wall that does not require fire resistance, then the window doesn't require fire resistance. But as I make a point in my brief, that doesn't necessarily follow. The fact is that windows in stairways is never addressed by the defendant, by the provision that it's relying on. In fact, the provision that we are relying on says that Class B openings are for stairways and in firewalls and party walls. In other words, the only conclusion is that windows not in firewalls but in a stairway must meet these requirements. The language, if the court is able to look at the language of the provision that we are relying on, it deals very clearly with this issue. A window that's in a stairway has to be a Class B window. A window that's in a firewall or a party wall, under certain circumstances, needs to be in a Class B window. But the window does not have to be, it's not what's the word I want? It's a conjunctive phrasing of the statute. It can be this and this. Either one of these is requiring a Class B window. And so the point I make in my brief, both below and here, is that in terms of statutory construction, special provision prevails as an exception to a general provision. In our view, the defense, Heslop, is relying on a general provision dealing with structural elements, walls, ceilings, and so on. A provision that never addresses at all windows. Our particular provision, the one cited by our expert, deals specifically with windows and defines what a window is and defines what is required of a window that's in a stairwell or a stairway in a building like this. Therefore, even if there is a conflict between the two provisions, the special provision, or the one that's dealing directly with a window, overrules and is an exception to the general rule that is set forth in the provision cited by the defendant Heslop. The other arguments in this case dealing with open and obvious doesn't work if there's negligence per se. This court has said that many times, or several times, as has the Supreme Court of Ohio, numerous times. In the case that I started out with, the court made it clear, the McHugh versus Zatar case, the court made it clear that open and obvious doesn't fly if negligence per se was in fact the case. Since the court below did not deal with negligence per se, or indeed with any of the issues in the case, if I follow what this court has done in previous cases, this court will remand to the trial court for that court to address negligence per se. If this court does not do so and chooses to address this issue, which I think it certainly could, I think the court should find in favor of the Smiths, because the provision that we're relying on deals with a special provision related to windows and not to the general provision related to structural elements.
And you're just now reaching into your 2 minutes of rebuttal time.
That's all I have. Thank you.
May I begin? May it please the court, counsel, my name is Greg Geis from the law firm of Reminger. I'm representing the App.No Heslop, Inc., the landlord in this case. Let me first address some of the issues that plaintiff's counsel raised in his argument. Specifically, this issue about whether or not the trial court needs to address the negligence per se element. My understanding was, and my recollection could be wrong, but I don't think so, that plaintiffs filed an affirmative motion for summary judgment arguing negligence per se in this case. I believe that motion was denied. And so in that respect, I believe that the trial court did address negligence per se, and that would not be a basis to remand this case at the trial court level. If I also remember correctly, I believe that Heslop, Inc. Included or may have filed a separate motion for summary judgment on negligence per se as well, an affirmative motion. I believe that too was granted on behalf of Heslop, Inc. So I don't think that whether or not the...
I recall the court, I'm trying to find a journal entry now, and I thought I had my iPad all worked out today, and now it's driving me crazy again. But the court did say, I think in her journal entry, that summary judgment was granted on behalf of the landlord, but then partial summary judgment on the issue of negligence per se. Is that what you're referring to?
I believe that is correct. I believe we filed a separate motion for summary judgment, a partial motion for summary judgment on the issue of negligence per se, and it was granted. So I do believe the trial court addressed that issue at their level, and there would be no need to remand the case on that basis. That being said, I do believe that, or I would ask you to uphold the trial court's decision on summary judgment for two reasons. First, there's no violation of any sort of building code whatsoever. And second, there's no evidence that Heslop Inc. did anything wrong or should be held liable for Mr. Smith's accident. Although I'm sure you're familiar with the facts, I just want to address a few of them before we go any further. Jeremy Smith was walking his two friends back to, well, he and his friend were walking their other friend back to her apartment. As they got there, the two friends, other than Jeremy, wanted to go and speak with each other privately. Jeremy kept peeking his head around the corner, I believe is how they termed it. At one point, the female friend, Mrs. Freimer, or Miss Freimer, begins to chase Jeremy. He runs toward this window. Ultimately, he either gets pushed or he falls into the window, thereby injuring himself. I think that what you'll find in the record are these two expert reports of experts looking at the building code and giving opinions about whether or not the building code required a stronger glass in this case. The defense expert, Mr. Yaquila, opines that the building code does not require a stronger window in this case, and that Heslop Inc. Met all the requirements for fire-resistant ratings with respect to the window. He looks at section, or say, well, table BB 902, and determines that this tells us that neither the wall nor the stairway where this window was located would require someone to have a stronger window in that section. I think that he refers to specific laws that were in effect at the time and that he's able to interpret, and I believe that those are the laws that convinced the trial court that there was no administrative violation here, and I believe that's correct. In addition, there were several other arguments made at the trial court level that would have enabled the trial court to grant summary judgment to Heslop Inc. In Ohio, even if there's an issue of negligence per se, there is still an argument about notice. And if the landlord is not on notice of a problem and shouldn't be on notice of the problem, then you can have a legal excuse for the defective condition if indeed.
I've always wondered about that, because isn't that inconsistent with negligence per se in general? In other words, to have negligence per se, you're assuming there's a duty, and now the case law is saying, well, you don't really have a duty if you don't have notice, which goes to foreseeability. And so doesn't that just stand it on its head in regard to negligence per se?
Well, I would answer that question no, and we can turn to general premises liability law to help us answer that question. In general, premises owners have a duty to take reasonable care with respect to defective conditions on the premises. That is kind of akin to your requirement to comply with codes, whether they're building codes or what have you. However, if a premises owner doesn't have notice of a dangerous condition on the premises and shouldn't have notice, they are still excused from liability relative to that defective condition. And I think that is the concept that's at work here with respect to landlords. And I think that was recognized by the Ohio Supreme Court in the Sikora versus Wenzel case. Which is where we find that proposition of law. I believe the court said, with this decision, we confirm that the doctrine of negligence per se countenances a lack of notice of a defective condition as a legal excuse.
I understand that's what the case law said, it just doesn't seem consistent.
Well, I think the idea...
If we just studied negligence tort law back in law school, it just doesn't make any sense.
Well, I think the idea, and again, it goes back to general premises liability laws, we're not going to hold someone responsible for something they didn't know about and shouldn't have known about.
Well, then don't call it negligence per se. That's fine.
I absolutely understand your point of view. All I can say is that the law does allow an excuse for that. Whether they should call it something else, I can't tell you that one way or the other.
Thank you for bearing with me and indulging me because it drives me crazy. Because it's just not consistent. I mean, it's not.
And I absolutely understand. I absolutely understand. There's a couple of ideas in Ohio law that I have problems with as well. In addition, when we look at negligence per se issues, we have to examine what type of accident or injury that particular law is designed to prevent. Here, this is a fire issue. And so even if Heslop Inc. had been incorrect with respect to the fire rating relative to this window, it's not a code or administrative regulation that deals with people falling outside of windows. That's not what it's designed to protect against. It's designed to protect against fire issues. And so even if Heslop Inc. didn't have the right window in place, it shouldn't have any bearing on whether or not they should be liable for Mr. Smith's accident. His accident had nothing to do with any sort of fire injury or trying to escape a fire or dealing with any sort of smoke inhalation relative to the window.
So there you're talking about proximate cause.
Exactly. And I think that's a big issue here, because at the end of the day, no matter what else we have going on, there's no proximate cause. Unfortunately, this gentleman was horsing around in the hallway with his friends and got injured on the window. Now, when we look at who's at fault for that, one thing to consider is plaintiff's expert says, well, if there'd been a stronger window, there'd be no injury whatsoever. But first of all, that's speculation. Second of all, it's unfounded speculation. Mr. Smith testified he's running full speed, he knows the window is there, he sees it, and then he gets pushed and flies into it. One of two things are going to happen when he hits that window. Either he's going to go through the window or he's going to slam into the window and get hurt either way. And so when we look at what's the proximate cause of the accident, it's not the window, because whether the window shadows or the window stays firm, this child's going to get hurt. The proximate cause of the accident is someone, well, first of all, is him running towards a window with nowhere to escape to, and someone pushing him and him falling into the window. So I do not believe that Heslop Inc. can be held responsible based on the lack of a proximate cause related to them. We also have the issue of there is no duty to protect someone from the actions of a third person if it's not foreseeable. I don't think there's any evidence in the record that it would be foreseeable for a landlord to think about whether or not people are going to be horsing around in the hallway to such an extent that they start slamming into windows that are visible and that they've acknowledged they know are there. So I don't believe that the foreseeability element would allow Heslop Inc. to be responsible for the actions of Ms. Freimer and, quite frankly, Mr. Smith himself. We also have the issue of superseding an intervening cause, much like the lack of a duty to protect from the actions of a third person. Once again, we've got an issue here of foreseeability. Heslop Inc. shouldn't be held responsible for not being able to foresee that these kids are going to be horsing around the hallway to such an extent that someone's going to get injured in this manner. And so Ms. Freimer's negligence in pushing Mr. Smith into the window is the controlling factor here. And quite frankly, if anyone's going to be responsible for the accident, it should be the people that are messing around and injuring themselves.
Is that undisputed in the record? Because it's a summary judgment that we're talking about. So the facts regarding what the injured party's thoughts were in terms of what was going to happen, or if he had a last chance to avoid the window, I mean, it seems like there would be a lot going on very quickly, and I wondered if the plaintiff had raised something that might be a material issue of fact as it relates to this proximate cause foreseeability issue.
I do not believe he did. The depositions that were submitted as part of the record are Jeremy Smith's deposition himself, as well as the deposition of Mr. Licata, who I believe is one of the owners of Heslop Inc. and essentially the landlord. Mr. Smith was pretty clear about what happened, and his is the only testimony in the record about the accident itself and how it went down. And if I recall correctly, he testified that he's running towards the window, he knows the window is there, he's cognizant of the window, he gets pushed, and he goes into the window. I believe he specifically admitted he didn't trip. I believe he admitted that there's nothing wrong with the floor itself. And if you would like me to find those quotes, I can, but...
There are some of them are in the brief already. I
Right.
appreciate that.
So-
You've answered the
Okay.
question, but I just want to make sure.
So in conclusion, I would ask you to affirm the ruling of the trial court on any one of the several grounds that we've presented, as well as the evidence that's in the record. And of course, I'm available to answer any questions if you have any before I sit down.
Seeing none. Thank you.
Thank you very much.
Your Honors, in addressing several of the issues raised by the defense and by the appellees, what this court has said, at least on 2 occasions, is that when the trial court does not analyze the negligence per se issue, it's not a matter of whether it mentions it in the judgment entry, but when the trial court does not analyze the negligence per se issue, then this court sends it back to them to analyze it. And that was not done here. There was no analysis whatsoever by the trial court in this case. In fact, the trial court, the Heslop provided the trial court with a 3-sentence judgment entry, and the trial court adopted it word for word.
But there's no requirement that, whether don't get me wrong, I would love to see it be required, but there's no requirement that the trial court could just say judgment, for summary judgment granted.
Well then, Your Honor, if I may, I don't understand why that you would have written here, however, this court remains a reviewing court. As such, this court will not consider the issues relevant to a motion for summary judgment in the first instance. And because the trial court failed to analyze the issue of negligence per se in its judgment entry, we are compelled to reverse and remand the matter to the trial court to consider the claim of negligence per se in the first instance. I mean, you used the word analyze, as did Judge Moore in the other case. The impression I have is that this court doesn't wants to review the case.
Or we just use the wrong word, quite frankly. And that's what I always think of when we're writing these opinions of how the attorneys are going to anticipate things. So I don't know. I obviously will go back and look at that case. But it just strikes me as being, I don't know what the word I want to use, that it doesn't seem realistic that we would say analyze one issue and not analyze another issue.
Well, I think that in the 2 other cases, I haven't seen those judgment entries, but I think there was some analysis of the other issues. Like the one case said that open and obvious is the dispositive factor in the case. But the open and obvious doesn't work when there's a negligence per se finding. So the other point, or another point, is the issue of proximate cause and notice. The point I made in my brief is that ignorance of the law is no excuse.
And Counsel, you have reached the end of your allotted time for today. Before we end this case, I want to let counsel for the landlord know that should you wish to address the argument related to the new case law that this court has just done so, please file that argument with a motion within the next 10 days, because we allow counsel for the plaintiff to argue this case before us this morning without a motion for supplemental authority having been filed prior to today's argument. The court will take this matter under advisement and issue a written decision which will be mailed to both sides, as well as posted on our website and the Ohio Supreme Court website.
Thank you, Your Honor.
Thank you, Your Honor.